Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hi there, just me. I'm about to bring you part 2 in our 3-part release of The Queen and Grant. I'm about to give you the concurring opinion of Justice Binnie. If you want to hear me and Zach chat about the case, or if you want to hear the majority reasons, head on over to the previous episode. Thanks so much. The following are the reasons delivered by Justice Binnie. I concur with the disposition of the appeal proposed by my colleagues, the Chief Justice and Justice Charon, and with their modified framework for determinations under Section 24(2) of the Canadian Charter of Rights and Freedoms regarding the admission or rejection of evidence obtained in a manner that violates the Charter. I differ with respect on their approach to the definition of detention in Sections 9 and 10 of the Charter. In particular, I believe their approach lays too much emphasis on the claimant's perception of psychological pressure, albeit as filtered through the eyes of the hypothetical reasonable person in the claimant's situation. My colleagues summarize their position on this point as follows. Detention under Sections 9 and 10 of the Charter refers to a suspension of the individual's liberty interest by a significant physical or psychological restraint. Psychological detention is established either where the individual has a legal obligation to comply with the restrictive request or demand, or a reasonable person would conclude by reason of the state conduct that he or she had no choice but to comply. My colleagues then set out a number of factors to help determine whether the reasonable person in the individual's circumstances would conclude that he or she had been deprived by the state of the liberty of choice. The court's continued embrace of a wholly claimant-centered approach may lead to the impression that it is more important to inquire whether the hypothetical reasonable person in the individual's circumstances would think himself or herself to be detained than whether he or she is detained. The perspective of the person stopped, or a reasonable person caught in that particular situation, is important because it is that person's liberty that is at issue. But in my view, the claimant's perspective does not exhaust the relevant considerations. I agree that there can be no detention unless the liberty of the person stopped is, or is reasonably perceived by that person to be, significantly constrained. But there may be much happening of which the person stopped is unaware, and this other context ought potentially to affect the legal characterization of the encounter. I agree with Professor Stewart when he writes that, quote, "The focus should not be exclusively on the state of mind of the accused. As courts of appeal have persuasively suggested, detention should also take into account the perceptions of the police. Otherwise, those perhaps most in need of charter protection against coercive police practices will have none. On the other hand, it would be unfortunate if preliminary police questioning of any suspect would have to be peppered with charter warnings." End quote. My colleagues do take into account some police-related factors. Example, whether the individual is singled out for focused investigation. But, as will be seen, they do so only to the extent this information is made evident to the person stopped. Also important, in my view, is an objective assessment of the facts of the encounter divorced from the perception of both parties, neither of whom may have a very clear idea of what is going on in the rush of events. Part A. When does a stop become a detention? While the uniformed police embody society's collective desire for public order and livable and safe communities, they also present a serious and continuing risk to the individual's right to be left alone by the state in the absence of objective justification for the state's intervention. Interactions between the police and members of the public are not only rich in diversity, but exceedingly common. Quite apart from police assistance offered to the general public, a traditional part of the daily routine of the cop on the beat is to check out suspicious persons. Clear guidance on the rules governing such encounters is, or ought to be, an important part of police training. This case is about a pedestrian. No one doubts the importance of being able to determine at what moment an interaction between the police and a pedestrian is converted into a detention of that individual, thereby triggering the rights subsidiary to detention, including the right to involve his or her lawyer, who can generally be expected to advise his or her client not to say anything further. In the first instance, it is the police who must decide if a detention exists because they are the people who administer the caution and inform the person detained about the right to counsel. Their intentions and perceptions will inevitably be factored into their determinations whether disclosed to the claimant or not, and should be taken into account in the legal test for detention when the matter eventually comes before a judge. A growing body of evidence and opinion suggests that visible minorities and marginalized individuals are at particular risk from unjustified low-visibility police interventions in their lives. The appellant, Mr. Grant, is Black. Courts cannot presume to be colorblind in these situations. At the same time, members of visible minorities may, as much as anyone else, be approached and asked questions by police. While, even more so than others, they may feel unable to choose to walk away, the perspective of police and the information, if any, the police possess when they initiate an encounter would help assess whether the liberty interest of the person stopped is truly an issue, even if the police perspective on the encounter is not made known by words or conduct to the person stopped. Part B. A brief history of the reasonable perception test. Our approach to detention, as with so much of this area of the law, draws heavily on the U.S. Fourth Amendment jurisprudence. Both societies, Canada and the United States, place a high value on the right of citizens to go about their business without being arbitrarily stopped by police and told to give an account of activities that they consider to be none of the police's affair. We therefore want a definition of detention that protects our liberty. Accordingly, in the Queen and Therens, Justice Ledin held, and subsequent cases have agreed, that a person is detained where he or she submits or acquiesces in the deprivation of liberty and reasonably believes that the choice to do otherwise does not exist. This approach corresponded to earlier decisions of the U.S. Supreme Court establishing that a person has been seized, i.e. detained, within the meaning of the Fourth Amendment only if, in view of all the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave. Justice Stewart in Mendenhall stated quite categorically that the subjective intention of the state authority, a drugs enforcement officer, to detain the respondent had she attempted to leave is irrelevant, except insofar as that may have been conveyed to the respondent. The approach of excluding from consideration information not reasonably evident to the person stopped is endorsed by my colleagues at numerous points in their judgment. The Mendenhall approach to detention adopted in Therens and affirmed in this case by my colleagues has different consequences in the United States than it does here. In relation to the right to counsel, for example, that right does not arise in the U.S. without delay upon a psychological detention or seizure, but only where there is a formal arrest or restraint on freedom of movement of the degree associated with a formal arrest. Whether such a situation of formal restraint exists under U.S. law depends on the objective circumstances of the interrogation, not on the subjective views harbored by either the interrogating officers or the person being questioned. In other words, in the U.S., psychological detention does not, without more, invoke entitlement to the assistance of counsel. The U.S. courts take a generous view of when psychological detention occurs because it triggers scrutiny under the Fourth Amendment of police conduct that would otherwise lie outside judicial oversight under their Constitution. In practical terms, the U.S. can live with such a broad claimant-centered definition because it does not have the effect of bringing in the lawyers at an early stage in encounters between the police and the citizen. The significant effect of a finding of detention in the U.S., as under our decision in the Queen and Mann, is to require the police to meet the standard of reasonable suspicion. Thus, the Mendenhall doctrine of psychological detention, when imported into Canada, raises a complication under Section 10b not present in the United States. Part C. Recognizing an obvious tension. In this case, Appeal Justice Laskin, speaking for the Ontario Court of Appeal, recognized that, quote, the definition of psychological detention reflects a judicial balance between competing values. On the one hand, the police have the duty and the authority to investigate and prevent crime in order to keep our community safe. In carrying out their duty, they must interact daily with ordinary citizens. Not every such encounter between the police and a citizen amounts to a constitutional detention. This court and other courts have recognized that police must be able to speak to a citizen without triggering that citizen's charter rights. On the other hand, ordinary citizens must have the right to move freely about their community. In the companion case of the Queen and Subaru, where the police intercepted an individual as he tried to leave an Ontario liquor store where a fraud had just been committed, Appeal Justice Doherty, also speaking for the Ontario Court of Appeal, recognized the obvious tension between the requirement to inform detained persons of their right to counsel and the proper and effective use of a brief investigative detention. Having found a breach of Section 9, Appeal Justice Laskin did not go on in the case to deal with Section 10b, right to counsel. However, as my colleagues treat Subaru in this court as a more or less straightforward application of their analysis of detention and grant, I propose to deal with both Sections 9 and 10b here. The Crown's argument is that by introducing a right to legal counsel, and to be informed of that right prematurely into commonplace interactions between police and members of the public, the court would hamstring essential police services and unduly tilt the constitutional balance against the public interest in effective law enforcement. For the police, in Professor Uvaler's mellifluous phrase, the confession is the queen of the evidentiary chessboard. When lawyers are on the scene, the potential for obtaining confessions tends to dry up. The defense, on the other hand, supports a broad definition of detention and quick access to legal advice, because under a less generous charter approach, a member of the public risks serious prejudice to his or her defense before the lawyer can get involved, since few members of the public are clear about their charter rights. The solution to this dilemma offered by the Court of Appeal in Subaru was to read down Section 10b so that the concept of without delay is stretched more readily to accommodate the reasonable needs of law enforcement, which in practice might well result in a situation similar to that prevailing in the U.S. The problem with the Ontario court solution, as my colleagues note, is that the interpretation does not sit easily with what those words mean, whether interpreted purposely, textually, or contextually within the Charter. The appellant, supported by the Criminal Lawyers Association Ontario and the Canadian Civil Liberties Association, suggests that the obvious tension could be eased by declaring inadmissible any incriminating statements made by an accused between the moment the detention crystallized and the subsequent notification to the accused of the right to retain and instruct counsel. However, this presupposes that the Section 9 detention has indeed crystallized, which is the point in issue. Another way to ease the obvious tension, other than to resort to Section 1, would be for the courts to re-examine the concept of psychological detention with a view to broadening the perspectives from which the encounter is viewed. This would help obviate some of the problems with a purely claimant-centered approach, in my opinion. Part D. Problems with the claimant-centered approach. I believe there are a number of problems with the court's continuing endorsement of the Therens-Mendenhall approach to determine when a simple interaction crystallizes into a detention. Insistence that the claimant's circumstances be viewed from a more detached perspective of a reasonable person provides in some cases a welcome corrective, but in other cases, by exaggerating the ability of ordinary people to stand up to police assertion of authority, that approach may compel the conclusion that the claimant had the choice to walk away, whereas in reality no such choice existed. Subpart 1. The perception of the police may be of significance. My colleagues refer to the complex situation, for example, when the non-coercive police role of assisting in meeting needs or maintaining basic order can subtly merge with the potentially coercive police role of investigating crime and arresting suspects so that they may be brought to justice. I agree that this subtle change of police perspective is relevant to the analysis, but it will not be made apparent to a person who is unambiguously stopped but remains unsure whether the encounter is benign or perilous. Police investigators assemble a mosaic of facts. Apparent general inquiries may be designed, unknown to the person stopped, to elicit the missing piece of self-incrimination. The success of the police investigation may indeed depend on the police skill in masking their information and intentions from the person stopped. Of relevance in this respect is the judgment of Appeal Justice Martin in The Queen and Moran, setting out some of the considerations he thought relevant to finding a detention, including the stage of the investigation, that is, whether the questioning was part of the general investigation of a crime or possible crime, or whether the police had already decided that a crime had been committed and that the accused was the perpetrator or involved in its commission, and the questioning was conducted for the purposes of obtaining incriminating statements from the accused. These are matters that would certainly be known to the police but not necessarily communicated to the person stopped. Perhaps, as mentioned, the stage of the investigation will be intentionally concealed with a view to a more productive interrogation. Other Moran considerations would be apparent to the person stopped. For example, the nature of the questions, whether they were questions of a general nature designed to obtain information, or whether the accused was confronted with evidence pointing to his or her guilt. If, for example, the police arrive at a street disturbance and it is not clear to them whether the occurrence is a crime or an accident, and they tell everyone to stay put until the situation is clarified, such a stay put direction should carry a different legal consequence than if used at what is clearly a crime scene to hold an individual they believe is a likely suspect. In the former case, the situation may be explicable by reference to police responsibilities for public safety and order. In the latter case, the police are attempting to gather evidence about and from a particular individual in relation to a particular crime. The reality is that in both cases, to borrow Appeal Justice Laskin's formulation in the courts below, any reasonable person hearing these words from a uniformed officer 3 feet away would treat them not as a request that might be ignored, but as a command that must be obeyed. Although in both cases, the police command to stay put will likely constrain psychologically the individual subject to the police direction from walking away, only in the latter instance ought the charter right to be triggered, because it is only in that instance that a person may reasonably require the assistance of counsel. Subpart 2. The uncertain characteristics of the reasonable person. In a useful commentary on the U.S. Mendenhall test, Professor Butterfoss writes, "Application of the test has created a broad non-seizure category of police-citizen encounters that permits officers substantial leeway in approaching and questioning citizens without being required to show objective justification for such conduct. This has been accomplished both by construing a highly artificial, reasonable person who is much more assertive in encounters with police officers than the average citizen, and by ignoring the subjective intentions of the officer. The result is that Fourth Amendment rights of citizens are determined through a legal fiction. In other words, encounters with police that average citizens would consider left them with no choice but to comply are denied the status of detentions through the device of putting in their place an artificially robust and assertive, reasonable person. Self-incriminatory conduct may also be rationalized in the state's favor by the attributed sense of moral or social duty on the part of every citizen to answer questions put to him or her by police. This gap between the reality on the street and the court-construed reasonable person is of particular relevance to visible minorities who may, because of their background and experience, feel especially unable to disregard police directions, and feel that assertion of their right to walk away will itself be taken as evasive and later be argued by the police to constitute sufficient grounds of suspicion to justify a man detention. Leaving aside the issue of visible minorities, is the concept of the reasonable person intended to describe average cooperative members of the public? If so, the Canadian reality is that such people will almost always regard a direction from a police officer as a demand that must be complied with. This was recognized in Therens and adopted in this case by my colleagues when Justice Ledin acknowledged that most citizens are not aware of the precise legal limits of police authority, and the reasonable person is therefore likely to err on the side of caution, assume lawful authority, and comply with the demand. Viewed in this way, police instructions or demands readily constrain a claimant's choice to leave, and therefore, on that interpretation, even the less intrusive encounters between the police and citizens ought frequently to be declared detentions, despite the fact that at that stage such people do not reasonably require the assistance of counsel. On the other hand, perhaps the reasonable person is to be invested with a higher level of legal sophistication, leading to a more robust attitude towards the police. My colleagues refer to the reasonable person assessment being informed by a generally understood legal rights and duties. This more erudite version of the reasonable person might know that apart from some statutory exemptions, he or she ordinarily has the right to walk away from the encounter, regardless of what the police officer says, unless and until the police possess reasonable grounds to suspect involvement in a criminal offense and therefore grounds for a man-type investigative detention. If the test envisages the perception of this more knowledgeable type of reasonable person, then anything short of an investigative detention as described in Mann would fail to constrain freedom of choice, and whatever is said in those critical early moments of an encounter will be presumed to be voluntary and based on consent. A further problem with the reasonable person device is to define exactly what information this fictional person possesses. While the factors identified by my colleagues include whether the police were providing general assistance, maintaining general order, making general inquiries regarding a particular occurrence, or signing out the individual for focused investigation, it is not suggested that the reasonable person is a mind reader. On their view, this information can only affect the reasonable person assessment to the extent it is made manifest to the claimant, whose perception would otherwise remain oblivious and unaffected. Yet, another difficulty with calibrating the reasonable person approach is that it is not at all clear what experience this hypothetical individual brings to the assessment of the encounter, and what criteria this individual applies in deciding whether or not the person stopped is free to choose to break off the encounter. There is a difference between the listing of a broad range of factors to be considered by a court and identifying their relative weight and importance. In the absence of explicit criteria, various judges will tend to read into the reasonable person their own projections of the moment at which, in their view, the person stopped ought to be able to call a lawyer. This creates the risk of a very results-oriented analysis. Perceptions will vary depending on the personality of the judge seized with the case. My colleagues emphasize at different places the need for deference to the assessment of the trial judge, which may further complicate the task of developing a consistent approach. In other words, continued reliance on the reasonable person whose attributed experience and choice of criteria are unspecified, except for a presumed commitment to reasonableness, helps to mask rather than clarify the actual criteria being applied by this court. Part E. Broader approach. As a majority of the court is satisfied with the Therens-Mandel-Hall claimant-centered approach, I will not belabor the existence of alternatives. However, I believe more attention should be paid to the objective facts of the encounter between a police officer and members of the public, whether or not such facts are made apparent to the person stopped. There is, of course, an important continuing role for psychological detention as perceived by the person stopped. But in that respect, serious weight should be given to the values and experience of the person actually stopped, including the experience of visible minorities, and less emphasis on the hypothetical opinion of the reasonable person, insofar as the latter is presumed to be able to handle such stressful encounters without sensing significant psychological restraint. As mentioned, Mr. Grant is black. In determining whether he, or a reasonable person in his position, would feel free to choose to walk away from 3 policemen, contrary to their wishes in the circumstances here, his ethnicity raises a significant issue. As the above-mentioned studies show, trial judges differ in the weight they are willing to accord to ethnicity in such low-visibility encounters, despite the overrepresentation of Aboriginals and other visible minorities in encounters with police patrols. That is why, from my point of view, the police perspective and the information, if any, the police possessed when they initiated the encounter is important to shed light on whether or not the liberty interest of the person stopped was truly compromised. I agree with my colleagues that a claim of psychological detention must meet the threefold test of 1. A police commander direction, 2. Compliance by the person now claiming a Section 9 detention, and 3. Grounds for a reasonable belief that there was no choice but to comply. However, in my view, police words and conduct should be interpreted in light of the purpose of the encounter from the police perspective, whether disclosed to the person from whom cooperation is requested or not. The U.S. Model Code of Pre-Arraignment Procedure, for instance, includes special provisions for questioning suspects as opposed to seeking cooperation from citizens, and requires warnings to suspects that no legal obligation exists to respond to questioning. The police know, but the claimant does not know, the point at which a person of interest begins to emerge as a suspect and ceases to be, as my colleagues put it, a person whose rights are not seriously an issue. A central problem with the Therens-Mandel-Hall claimant-centered approach as I see it is that it does not take adequately into account what the police know, and when they knew it, except insofar as the information is conveyed to the person stopped, but which the police may not consider to be in their interest to convey. Police may know, as in Subaru, if a crime has allegedly been committed and whether they are making the approach to an individual with a view to obtaining general information, or, on the other hand, corralling a suspect and collecting admissible evidence to bring him or her to justice. Possession of such knowledge may in fact place the police in an adversarial relationship to the person approached, whether that person is aware of the jeopardy or not. It is the adversarial relationship together with the stop that generates the need for counsel. At that point, the power imbalance is significant. The unsuspecting suspect may fatally compromise his or her position simply through ignorance of his or her rights and the fact that police have now adopted an adversarial position. At that point, as Justice Ledin put it in Therens, a person may reasonably require the assistance of counsel, but may not have any idea of the perilous turn of events. On the other hand, a more benign police purpose may deprive even an unambiguous police command of the legal effect of a detention, and thereby ensure to the benefit of the Crown. Had Constable Ruffley in the Subaru case, for example, come rushing up to Mr. Subaru in the parking lot of the liquor store saying, "Wait a minute, I need to talk to you before you go anywhere," because police had just received information unknown to Mr. Subaru that Mr. Subaru's van had been wired with an explosive device by local members of the Hells Angels, the detention analysis ought to be quite different, although the constable's words and the forcefulness of their expression may be the same. It is not controversial that in the early stages of a criminal investigation, the police must be afforded some flexibility before the lawyers get involved. The police do have the right to ask questions, and they need to seek the cooperation of members of the public, including those who turn out to be miscreants. The question is how to accommodate that need within a plausible framework of the Section 9 analysis. In my view, without wishing to prolong this discussion, a better and broader approach to detention would explicitly take into account 1. The objective facts of such encounters, whether or not evident to the person stopped, as well as 2. The perception of the police in initiating the encounter, whether or not evident to the person stopped, and 3. Whatever information the police possess at the time, which may or may not be known to the person stopped, as well as whatever change in the police perception occurs as the encounter develops. These matters should all be factored into a more comprehensive analysis of when a detention occurs for charter purposes than is provided in the Therens-Mendenhall claimant-centered approach affirmed today by the court. Part F. Application to the facts. In this case, I agree with my colleagues that Mr. Grant was arbitrarily detained. The safety of school neighborhoods is of great importance, but under our system of law, it cannot be achieved by random detention of pedestrians on the off chance that some of them might or may not be implicated in criminal activity. The purpose of these police officers, whether or not couched in terms of community policing, was to investigate crime, whether actual or anticipated. Constable Worrell testified that when the officers drove past an unmarked car, Mr. Grant stared at them in an unusually intense manner and continued to do so when they proceeded down the street. He wore a, quote, big jacket and was, quote, fidgeting with his coat and pants. Staring at an unmarked car and fidgeting are lawful activities, but it was enough to cause 3 police officers to converge on Mr. Grant. The police purpose for initiating the encounter is important, I believe, and Constable Worrell testified, question, well, when you stop these people, I take it, the object of the exercise in light of what you said about the nature of the area is to find out if perhaps they might be involved in swarmings or robberies or drugs? Answer, that's correct. Question, and when you and your partner talked about potentially stopping Mr. Grant yourselves and what you had in mind was having a chat with him? Answer, Question, to determine whether he might be involved in swarmings or robberies or drugs, correct? Answer, it's possible he may have been. We didn't know for sure. The police had no information whatsoever that Mr. Grant may have been implicated in a criminal activity or even whether a crime had been committed. But Mr. Grant's further, quote, fidget with his jacket convinced Constable Gomez to take charge of the situation, whether or not Mr. Grant was aware of how his fidgets were being interpreted by Constable Gomez, and to order Mr. Grant to, quote, keep his hands in front of him, end quote. That command crystallized the detention. However, in my view, the finding of a detention is properly the product not only of Mr. Grant's perception, filtered through the hypothetical reasonable person, but also of the objective facts of why the encounter was initiated, crime detection, and the other facts surrounding the encounter, whether or not evident to Mr. Grant. Example, the agreement among the 3 officers, unknown to Mr. Grant, to converge on him and thereafter effectively to form a small phalanx blocking the path in which the appellant was walking. As Mr. Grant did not testify, we do not have any first-hand evidence of his perception, although his lack of choice must have been manifest when every time he moved, Constable Gomez, who was standing only 3 feet away, moved in a corresponding way to maintain the nose-to-nose impasse. What we do have in considerable detail is the perception of each of the 3 police officers. Their forthright account of their own intentions, and their acknowledged lack of any information that any crime was or was about to be committed, apart from a, quote, hunch, none of which was conveyed to Mr. Grant, give rise to the conclusion that Mr. Grant was arbitrarily detained. I therefore concur in the conclusion of the Chief Justice and Justice Charon that Mr. Grant was detained. I also agree with their analysis under Section 24(2) and the consequent disposition of the appeal.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.